Hello, my name's Doug Law. I'm an attorney here in California, practicing in the area of lemon law, which I have done for 25 years on an exclusive basis. The first question and most common question I get is, do I have a case? And do I have a case under the California lemon law is of course a complicated question involving a lot of different factors. But the first thing that we're looking at, and probably the most important thing, is how many repair attempts have there been under warranty to the vehicle. And repair attempts are not just for one problem. Repair attempts are for the vehicle as a whole. That does not include a service like an oil change, but it is counted as a repair attempt anytime the vehicle is presented for repair of a problem. Whether or not the dealership can duplicate the problem or actually performs a repair, we want to know how many times a particular issue has been complained about at the dealership. If we have a confirmation of that in writing through a repair order, that's great. We always look at the repair orders. And if there are repair attempts where the dealership actually attempts a repair, that's also good. But repairs under the lemon law include each presentation for repair and not just the number of times that a dealership actually performs a repair. So that's the first question. How many repair attempts have been performed on the vehicle? The second question is whether those repair attempts have occurred during the warranty period. Lemon law is always concerned with repairs under warranty. And so typically a vehicle is going to have a bumper-to-bumper warranty for 3 years and 36,000 miles, and we're going to count up the repair attempts within that period of time. The third thing we're going to look at is what have the defects involved. Are they serious? And there's a sliding scale there. There's a difference between a shake or a rattle, and what might be a reasonable number of repair attempts in that context versus a stalling issue where the vehicle is shutting down on the road, and it might involve safety, and what would be a reasonable number of repair attempts for a problem like that. Under the law, there is a presumption that 4 or more repair attempts in the first year and a half or 18,000 miles of use qualifies the vehicle as a lemon under our law. But I would also say that probably 80% of my cases do not meet that presumption. There is another presumption regarding days in the shop. We're also going to look at how much time has the vehicle spent out of service because of these repair attempts. And 30 days in the shop, again, in that same year and a half or 18,000 miles, qualifies the vehicle for a lemon. And again, I would say 90% of my cases, maybe 95% of my cases, don't meet that 30-day standard. It's not required. The standard is when has a reasonable number of repair attempts been exceeded.